Nobody's here. This is very inappropriate behavior from our justice. Just grab me.
Yourself.
Grab me.
Oh, yeah, I could do that.
Am I allowed to have cameras out in court or no?
Yes,
Randy.
you are.
Nobody
So
wants
there might
to.
not be opposing counsel.
Well, nobody wants to go against you, man.
No, that's not. That's not it.
That is the case.
It's the timing, unfortunately.
Sure,
For a lot of people just have literally,
Oh,
walked out of
everyone
one
switch
job
fucking
and into
sides
another.
right now.
The
Fuck the
judge is
police.
gonna be here in about 10 minutes.
Yeah, but they scheduled this with that in mind.
Yeah, I mean,
So it's not a very good excuse.
availability.
Yes and no.
Yes and yes. See, if we were late, then we would have been screwed. Yes or no?
Oh yeah, if I'm late, I'm screwed. But I'm never late.
Yeah, see?
Fuck police.
Bloody hell, sorry about that, everyone.
We will have justice.
We will.
Justice for
Wait, why did he say sorry, everyone? Is he gonna be the one that's the justice?
He's the judge. Justice, yeah.
Can I go up top?
What? He's Buchanan?
Yeah, Randy, you got this, Randy. Fuck Patty the bear.
Look how many people are on our side, bro. I love it.
Oh, I know. It's bad.
Where's Oliver Hall?
Oliver Hall is not here. He's a judge.
Yeah, but
he's
it's
not
about
gonna
him.
be here. He's not gonna be here.
He might be here.
The voices in my head are telling me to do bad things.
Oh, he is here.
What do you mean?
Look up to the left in the balcony. He's got binoculars.
I can't. I'm not gonna listen.
Yo, what's
but I
up,
can't turn it
Oliver?
off.
Sit down, dude. There's no intermission.
Look how much of a pussy he is. Why doesn't he come down here? Like a man.
Alright, court is now in session. Introducing Justice Richard Buchanan for Leo Zax versus, or the State of Los Santos versus Leo Zax.
You can tell everyone they can sit down.
Oh, you can sit down.
Everyone was already sitting.
Alright, everyone hear me okay?
Yes, Your Honor.
Perfect. Okay, sorry about the wait. I apologise, I was running a little bit late today. Okay, so, I mean, I suppose before we kick off the appeal, is there anything that needs to be sort of brought before the court before we begin?
No, Your Honor. We have nothing to present other than arguments today.
Perfect. Okay, so it's a little bit of a strange situation. Obviously, a summary judgment being issued by a judge. Obviously, the DA's office is not really getting involved in this, so there won't be anyone to kind of represent the state as such. So defense or the appellant, should say. If you want to kind of present your case and stuff, we'll give you obviously 10-15 minutes or so to do so. You can sort of bring up any arguments. Obviously, we won't be introducing any new sort of evidence or witnesses, obviously due to it being an appeal, and we'll kind of go over everything as we go. If you have any questions, obviously just feel free to ask.
Liberal sissy.
May I approach to present our argument?
Of course.
Thank you for hearing our appeal, Your Honor. The appellant, my client, argues that the district judge erred in imposing a summary punishment against my client for contempt of court. Rather than following established federal law and court precedent, and despite warnings from colleagues, Judge Oliver Hall elected to violate the 14th Amendment of the United States Constitution by denying my client the right to due process. Regarding the right to notice and hearing versus summary punishment, the appellant's argument relies on federal law, established codes, and multiple precedents set by the Supreme Court of the United States. The first of these is Cook v. United States, where the court held that summary punishment is only appropriate when the contemptuous behavior occurs in open court and is witnessed by the judge. The court reasoned that such summary vindication of the court's dignity and authority is necessary to preserve order in the courtroom. In Harris v. United States, the court held that statements made outside of open court do not constitute contempt in the actual presence of the court for the purposes of Rule 42A of the United States Federal Rules of Criminal Procedure. Rather, such activity is only punishable after notice and hearing when there is no disturbance in the court's proceedings or need to immediately vindicate the court's authority. The appellant contends that this interpretation of the Due Process Clause is binding on both federal and state courts. Therefore, when it is not clear that the judge was fully aware of the contentious behavior when it occurred, a fair hearing would entail the opportunity to show that the version of events relayed to the judge was inaccurate, misleading, or incomplete. Based on this established precedent, and under the guidance of Rule 42A of the U.S. Federal Rules of Criminal Procedure, the appellant argues that the judge erred in imposing summary punishment without providing notice in a hearing. The appellant contends that Judge Oliver Hall did not personally witness any disturbance, violence, or physical obstruction, or disrespect to the court. This is evidenced in Incident Report 670, written by Judge Oliver Hall himself, where he states he did not personally witness the alleged statements made by Mr. Zaxer. He instead based his decision solely on hearsay from a member of the gallery, and felt that was enough to summarily hold Mr. Zaxer in contempt of court without notice or hearing. Again, even though the alleged statements did not obstruct the court and were not personally witnessed by the judge in open court, Judge Hall elected to forego my client's 14th Amendment right to due process based on a single statement from an individual in the gallery. Regarding limitations on contempt powers, the appellant's argument relies on Article 3 of the United States Constitution, Rule 42A of the U.S. Federal Code of Criminal Procedure, as well as Offutt v. United States and Mayberry v. Pennsylvania. In Offutt v. United States, the court set aside a criminal contempt conviction imposed after a trial marked by personal recriminations between the trial judge and the lawyer. The majority of the justices felt that any contempt trial must be held before another judge when a judge becomes personally embroiled in the controversy with an accused. This holding was constitutionalized in Mayberry v. Pennsylvania, where a defendant acting as his own counsel engaged in quite personal abuse of the trial judge. The court appeared to leave open the option of the trial judge to act immediately and summarily to quell contempt by citing and convicting an offender, thus empowering the judge to keep the trial going. However, if he should wait until the conclusion of the trial, he must defer to another judge. The appellant can prove that Judge Oliver Hall waited until after the trial at hand to cite and convict Mr. Zaxer. Furthermore, Judge Hall himself confirmed that he became personally embroiled with the controversy, in which case he should have deferred the contempt charge to another judge for a hearing. Instead, Judge Oliver Hall made the decision not to defer the trial for contempt to another judge, instead opting to forgo court precedent and Rule 42A on the limitations of contempt powers and summarily punish Mr. Zaxer with contempt without a hearing, let alone a hearing by another judge. The appellant argues that Judge Oliver Hall's decision to summarily punish Mr. Zaxer without a hearing and his failure to defer the ruling to another judge is contrary to established rules and precedent. The appellant contends that Judge Oliver Hall's actions constitute judicial misconduct by not abiding by Article 3 of the U.S. Constitution, Rule 42A of the Federal Rules of Criminal Procedure, or precedent established by the United States Supreme Court in Cook v. United States, Harris v. United States, Offutt v. United States, and Mayberry v. Pennsylvania. Your Honor, Article 3 of the United States Constitution establishes the judicial branch of the federal government and outlines its powers and responsibilities. It is important for the state of San Andreas to recognize this because it provides the foundation for the entire judicial system in the United States. Rule 42A of the Federal Rules of Criminal Procedure governs the procedure for contempt proceedings in federal courts, as well as state courts. It is critically important because it provides a clear set of rules on how contempt proceedings should be conducted. As the DOJ handbook in this state contains no limitations on judicial authority, no code of ethics for the judiciary, and no established rules on the rules of procedure for the judiciary, Rule 42A, and honestly, the entire federal rules of civil and criminal procedure are important to recognize in the state of San Andreas. Precedent established by the United States Supreme Court in Cook v. United States, Harris v. United States, Offutt v. United States, and Mayberry v. Pennsylvania provides guidance on how to interpret and apply Article 3 and Rule 42A in cases. These cases are extremely important because they ensure that judges are consistent in their interpretation and application of these rules, which helps to ensure that their decisions are fair, just, and do not violate any of the accused rights. By following these rules and precedent, judges can ensure that their decisions are fair, consistent, and in accordance with the law. This helps to maintain public trust in the judicial system and ensures that justice is served. This ruling has tarnished my client's reputation, destroyed his clean criminal record, and was the kindling that resulted in his termination from his career at the LSPD. He was accosted for pleading his innocence, shunned by friends and law enforcement, and targeted by those seeking retribution for his outspoken displeasure with the misconduct that we've described in this appeal. Because of the egregious misconduct by Judge Oliver Hall, we ask that you overturn Mr. Zax's conviction and award him restitution for lost wages and his time spent in prison, or at least afford him the opportunity to have a fair trial so he may plead his innocence in accordance with the 14th Amendment. Thank you, Your Honor.
All right.
That's my man.
You killed it.
Okay. Thank you for that. Obviously, in the absence of anyone representing the state, I'm gonna go back. I'm gonna think obviously over what you've spoken about today. I'll consider obviously every argument you've made in regards to Rule 42A, Article 3. What was it? Cook, Harris, Offord, and Mayberry. I believe that was most of it. I believe they're the main points.
Yes, Your Honor,
And,
that is correct.
Yeah. I'll obviously I'll come back in just a few minutes. Okay.
Thank you, Your Honor.
Perfect.
Really? So he's just gonna... I mean, he didn't even try arguing it.
He's not here to argue it.
Oh, he's not?
That was the job of the prosecution, and they didn't show up.
Huh. Oh.
The judge is just here to rule on the appeal.
Court is now in recess for 5 minutes. Use this time to do your business.
You saw Randy out there? Impressive stuff,
Yeah.
right?
Very sexy.
I love that last part. That last part was amazing.
Fucker,
sir.
Wait, if he said that the DA doesn't want to touch this, then they probably won't go to trial, since the DA doesn't want to
Probably
even
not.
touch it.
No, they'll probably just overturn the conviction.
I got another officer inside the courthouse.
Look at fucking Oliver up there, bro.
What's that?
Look at Oliver up there, man.
That's hilarious.
Alright, sit down now, or you're going to both get thrown out of the courtroom.
What's up?
Wait, does this mean we can play kickball in
I
here
feel like
since
you
this is
gave an amazing ass argument that like cannot be countered. He has to accept it, but I don't know what the fuck they're gonna say, man. We've been through too much. I forgot what it's called. Damage control. For them, the best thing they could do is overturn this. Just let it go. Make it a pass thing. That's the best case scenario.
Randy,
Yeah. What's up?
give me a smooch.
What?
Give me a smooch.
That's such a wholesome moment right there. Oh my god.
Oh, court's going back in.
God damn it.
The judge is back.
God damn it.
Looks like he was actually in charge.
The Honourable Chief Justice Richard Buchanan presiding.
I need to get in here.
Chief, sorry, Justice Richard Buchanan presiding.
Chief Justice.
Everyone in here, everything in your car has been stolen by people, even my shit.
That's a lie. He's working for the gang.
Obviously, I appreciate that this situation isn't a common one, nor is it anything kind of typical. So what I'm going to do, obviously, in the absence of anyone representing the state, I do want to just call Judge Hall down, if he would. If he'd entertain me. I know it's a bit unorthodox, but bear with me.
That is unorthodox. Look at him stumbling his ass. Bring your ass down here, man. He doesn't even know.
Hello
Do
there.
you want to come forward just a sec? A little bit closer? Alright, so just to let everyone know, Judge Hall's going to be providing just a sort of small narrative. Like I said, in the absence of anyone sort of representing the state, I feel like it's beneficial to have him kind of provide his perspective, his side. And obviously we'll go from there, and then I'll mention obviously the decisions I've made in terms of case law and federal law and sort of stuff. Okay?
Thank you for the opportunity, Your Honor.
Now, I'll go through the factual findings as to the contempt. I want to make quite clear, as to current law, before the court rules on the law of contempt and what's recognized in San Andreas. At the time that this decision was rendered, Mr. Zax, well, the current law, there really was none. None in the handbook, none recognized or no previous contempts that were made in this manner, to the best of my knowledge. So, as far as any actual procedure, as far as contempt goes, the case laws that have been cited thus far, they aren't previously recognized, nor could they have been used by myself or any other party in rendering a decision on contempt, or any other case at the time that the contempt was issued. So really, if you think of it this way, there was no real set procedure to go off of when it comes to contempt. Now, as far as the factual findings, to the best of my recollection,
I think he stepped in dog shit.
Yeah, so as far as the factual findings go, it was brought to my attention after the trial occurred that Mr. Zax had made statements of disrespect towards myself while I was attempting to climb the steps at the time. I had been bound to a wheelchair, and I believe, if I recall correctly, I had to be escorted up to the bench. Mr. Zax was making these comments in the gallery to other known and unknown parties at the time. He was making these statements.
Objection, Your Honor.
I'm sorry, I'm not sure.
Objection, Your Honor.
Sorry?
I'm objecting to this, Your Honor. This is beyond the scope. He's assuming facts that aren't in evidence, as there is no evidence.
Yeah, I think we'll get to that. I have questions of my own. I'll ask them in due course. Again, I appreciate this whole situation is pretty unorthodox, obviously, for this sort of thing. But yeah, just bear with me, okay?
Yeah, so as I was saying, the statements that Mr. Zax were making, I'd have specifically, as far as it goes, I know I made some report in official order as to contempt. So as far as the specific words that were used, those fail to come to mind at present. But they were directed at me. They were disrespectful in nature. They demeaned and undermined the authority of myself as the presiding judge in the case. And again, they were made, I was made aware of them after the case. I believe the defendant failed to appear, if I can best recall. So it was after the case was adjourned, it was brought to my attention. At that point, Mr. Zax, I believe, was still either in the building or he had left. The statements had been brought to me by Judge Castle. He had given me a full accounting as to what he heard to the best of his recollection. He described Mr. Zax having made the statements. He described what the statements were. And from there, I believe there was one other officer in the room that may have corroborated it, but I can't quite recall it at present. From there, Mr. Zax came back to the courtroom, at which point he was confronted at the lobby of the courtroom by myself, I believe. I asked him, I believe his supervisor was there, I think Lieutenant Adams it was. He was asked as to why he made the statements, and eventually he admitted to making the statements, said that he apologized after denying multiple times that he had denied. After I had found him contempt, he, I think, eventually admitted to making the statements, and he was sentenced to, I think, 1 month imprisonment.
Yeah, I believe
Your
so.
Honor, I'm going to object again on speculation.
Yeah.
What am I speculating as to?
You're speculating as to whether or not Mr. Zax made the statements in the first place. You're speculating as to whether or not he actually made the statements, because you said, "I think he admitted to it," and he was not under oath at that time. He was not making a sworn statement, so this can't be held as evidence regardless.
Yeah, I'm certainly happy to get back into the law of it and give my reasoning as to that, if you'd like, Judge or Justice.
Well, I mean, I have one question, obviously, before I sort of continue with that. So you didn't hear the statement yourself, no?
No, I didn't hear the statements directly.
Okay, so in regards to obviously hearing or knowing that Mr. Zaxer obviously made those comments, I'm going to sustain the objection. So obviously we'll take that into consideration. If you want to continue.
Certainly, I'm happy to. Yeah, I didn't directly hear Mr. Zax make these statements. Again, the evidence of that was brought to me. He eventually admitted to making the statements. I was comfortable based on the facts that were presented, making a finding as to the contempt, that proper facts had been established, and that a punishment was warranted to issue a contempt. Now, I'm fully aware that on the federal level in other states, the court, if they don't directly witness a contempt or there may be some sort of conflict, they generally appoint a different attorney, either the prosecutor or an impartial attorney, to prosecute the contempt that they issue, and they either hear out the case or another judge hears out the case. But that is completely impractical in San Andreas, and there certainly was not any requirement at the time for that to take place, so it didn't. I, the presiding judge, made a finding of the facts as to the contempt, heard out Mr. Zax, and issued the contempt based on the findings. Mr. Zax, of course, was present. He had the opportunity to speak for himself. Again, he admitted to making the statements eventually, and he was found in contempt. There was one more thing I was going to say. If you have any questions, I'm happy to answer.
I don't think I have any at the moment. Alright, so if that's everything, thank you for your time.
Not a problem, Judge. Thank you.
Appreciate it. Alright. So obviously with the narrative obviously provided by Mr. Hall, I will sort of inform you of my decisions in regards to the case law, the Federal Rules of Criminal Procedure, and Article 3. So in terms of Cook, Harris, Offord, and Mayberry, obviously the state hasn't recognized them as binding precedent or whatever, so we'll consider them as persuasive, but their actual precedent they set we're not going to take into consideration as law. Rule 42A is a difficult one, and obviously this comes into play really when we consider that San Andreas is not a typical state of the United States. There are many things throughout federal law and the Constitution that we don't abide by, which makes this case a little bit more difficult to rule on. With that being said, I will say that obviously if we affirm it in a Supreme Court ruling, then obviously it will be considered binding, it will be adopted into San Andreas state law until repealed otherwise. I will also encourage you to make any sort of legislation proposition as well, or anything else that you want to include. But at the time, unless you have anything else to add, Mr. Savage, I'll give you another opportunity if you want.
Yes, Your Honor. The only thing I would add here is even if you don't consider the case law presented as actual precedent and simply as persuasive, if you don't consider Rule 42A, at least consider the fact that my client was denied due process. The judge ruled only based on hearsay from one individual and denied my client the right to due process, the right to a trial based on hearsay. If that is acceptable in the courts of San Andreas, then there is a systemic issue that needs to be resolved.
Well, that's lovely. Yeah, so obviously I understand what you're saying. I obviously appreciate your point. That will be taken into consideration. Or it is already in consideration. So here is my ruling on this matter, basically. As far as I can see, what Judge Hall is saying is correct. He is saying that obviously at the time of the contempt of court, as it was written in San Andreas law, there was no requirement for it to be within a court that was in session. However, I feel like this situation is probably as good a time as any to make that San Andreas law with binding precedent. So at this moment in time, I'm going to be overturning the conviction of contempt of court. What sort of restitution were you seeking? Sorry, there might be a time for a different time for this, but I'd like to hear it anyways.
Yes, Your Honor. So we're requesting restitution for the lost wages and his time spent in prison.
Okay, is the lost wages that in regards to his employment at LSPD?
Correct.
Okay, and do you have a number?
We would have to total that number up, Your Honor.
Okay, so I'm not going to grant that restitution, obviously, yet. I could just do it in the appeal. Again, it's not orthodox as such. But I think we can definitely talk about it at a later date and sort of discuss what you're seeking and if it's reasonable. But I'd also, in a way, I'd also like to sort of hear from the LSPD's command members and all sorts of, all their command teams. To kind of ascertain Leo Zaxer's status of employment really before for his termination. Okay?
Okay.
Cool. So, like I say, the conviction of criminal contempt of court is going to be overturned. I mean, you're more than welcome to post-exoneration restitution in that regard, which I believe, as it stands right now, is a grand total of $50.
Your Honor, he actually ended up spending about 20 months in prison. I don't know whether that was a clerical error on the side of the prison or what, but he definitely did not spend a single month there.
Okay. I will have a look into that for you, and I'll see what I can find out about it. And obviously, I'll approach you at a later date and see if we can get that sorted.
Okay. Thank you, Your Honor.
Okay. Okay, just one last thing, obviously, before I adjourn the court. In regards to Rule 42A and Article 3, I think there needs to be a little bit more sort of investigation. The trouble is, obviously, with San Andreas, is that we create the laws and render decisions based on what is best for the state. So I think more sort of open discussion needs to be had about exactly how we're going to deal with it, because obviously there's a lot of things in typical American law that wouldn't make sense here, and I think that needs to be taken into consideration to make sure we keep the best interests of the state in line. All right.
Understood, Your Honor, and we'd be happy to work with the DOJ in establishing that.
Yeah, absolutely. All right, perfect. Okay, court is adjourned.
Did he hear the verdict, Oliver?
Oh yeah, I'm sure he did.
Good shit, man. I'm proud of you, bro.
Sorry about that. I just gotta get out of the door now. Oh, thank you.
Good job.
Thanks.
Give me my kiss. I've been waiting.
Can somebody let me out?
Wait, me?
No, not you.
All right, we're gonna have to. I'm gonna have to do it.
Oh shit, you got this. Oh.
Woo!
Yeah.
Yeah.
That's class right there.
As a cop shows up. Yo, Miles, baby.
I made it.
Did you hear?
Welcome.
I made it. Jesus. Yeah, I couldn't get in because they wanted to. There was something going on out here, so I just walked up the stairs and went in the balcony.
We won, baby.
So,
we won.
I've seen.
Let's go. It's all Randy, baby. Look at him. He's good. He's a beast.
I'll make sure to hire him when I need him.
Exactly.
It was close. We got close.
Oh, wait. Oliver was there.
Killing somebody else.
Leo, your suit is getting very moist. You should whip out your umbrella.
I'm too happy right now.
Okay.
I know, you're clear.
Moist and happy.
All this for what, man?
I was like, damn. I was like, he's getting everything. It's like, yeah, let's go.
I won, but at what cost? I can't join LSPD anymore.
From now on, he will be known as Soggy Sanders.
Why can't you join PD?
Because they don't want me there.
That's what the fuck? That's not a choice.
You know, all because I wore a hat. And
are we back to the hat thing that you actually had a fucking religious thing for? That's
exactly.
Weird.
And they spat on my religious document. Yeah.
That's another lawsuit. They better start working, Randy. He's calling you back.
No, we're on it.
So how'd the case go? Sorry, I was, dealing
We
with
won.
something. Oh, well, I guess congrats
Yeah.
to you, sir.
Yeah, the
Thank you.
conviction got overturned.
Why are you always reaching, man?
Hey, look, did you not just see that guy that I had transported back? You
Who was
never
that guy?
know. It was Jake Fuller. He had an active warrant out.
Shit. Man. Gosh darn.
Yeah, I just went up to the balcony, to be honest with you.
Yeah, it's all good.
I was
Anyways.
surprised when he called Judge Hall down to the stand.
All he wanted to hear was that he didn't hear it from me. That's all he
Yeah.
wanted to hear.
Yeah, I heard that. I was like, damn. I was like,
I hate court.
The fact is, he's like,
back to PD, okay? You guys stay safe, stay dry.
I'd rather do
Don.
court than
I
just
bet
sit
my
in an
car has a
PD
flat
room.
fucking tire now, doesn't it?
the crazy thing to me is that he said, he went from saying, "Oh yes, Judge Castle told me that he said this stuff," to the things that Leo said were very disparaging. It's like, well, no, you don't know that he said. You were told that,
I
but
was
you
gonna
don't
say,
know
dude,
that.
it could have been
happened.
any motherfucker out here.
We know exactly who it was.
Yeah, it wasn't me.
It wasn't him, but we know exactly who it was. But they won't do anything. to
Cisco
that.
baby. Ignored me.
Yeah, I think he's moody right now.
What's that?
Said I think he's moody right now.
Oh, well, probably because he didn't show up for freaking court.
Contempt.
They're holding
Charge
his
him.
ass in contempt.
Charge him.
The hell, the judge didn't even show up until 10 minutes after the court date was supposed to start, or the court was
That's always
supposed to
good.
be in session.
That's a good judge right there. Hashtag not my judge.
I can't believe we did it, man. I was screwed so hard by all this, man.
Yeah, but we knew you were gonna get that fucking off. Like, it was bullshit from the beginning.
Yeah.
Oh, y'all ready to evacuate?
Oh,
Come
yeah.
Back here for another trial?
Yep.
Oh, you have another trial after this?
I don't,
Ah.
but you're gonna want to see this next one's coming up.
Yeah.
What is it? Is there another one
It's-
coming out?
It's Panjeet from the family. He's representing himself.
Oh.
What time is that? What time is
Wait, he is?
Yeah.
I
What
would
time does that
love
happen?
to see that, but I have my first shift at UWU.
Wait, fuck Uwu.
No.
No, it's my
maybe you
first
can-
shift.
Maybe you can talk to Andy, because Andy's
Maybe.
probably gonna come to.
Okay,
think-
yeah, I'll talk
Randy-
to Andy after Tsunami.